So I hope everybody can see and hear me. And I'm excited about doing this, and I hope everybody else is too. And I'm sure you're going to learn quite a bit from this webinar. So without taking too much of your time in terms of introduction, I can start. Most of you, if not all of you, already know who I am. I'm an immigration attorney. I've been practicing in the LA area for approximately 20 years. I've been doing, I started my practice as a business immigration attorney. I've practiced both in Orange County and LA County areas. And then I've expanded my practice. I've stayed within the immigration base, but I've expanded it from employment to investor visas, family immigration, court, appeals, and we handle anything and everything that you can possibly think of, including criminal immigration matters, from our office. We have a network of 4 immigration attorneys and a staff of 10 legal assistants and paralegals in the office. Our main location is in Los Angeles area, and I'm happy to answer any of your question or your family, friends' questions. When we're done with the webinar, you're welcome to contact the office. I offer free consultations, and we can take the case into more specific areas of your interest. So let's talk about, I'm going to put up something on the screen, and I call this a big picture, and we'll go through some of the things that I emphasize to my clients when they come in. So on the big picture, you can see that there are 2 different sides to this picture. One is a non-immigrant, and the other one is an immigrant side. And the reason that I broke this up into 2 different squares, if you will, is because non-immigrant immigration and immigrant immigration really don't have much correlation between one another. There is some overlap in certain types of visa types in terms of how you are eligible and how you can qualify for the immigrant section once you have a particular non-immigrant visa. But generally speaking, just because you have one of these non-immigrant visas that's on the left side of your screen, it doesn't automatically, in and of itself, turn into a green card. You have to start an immigrant process, the things that are labeled on the right side of your screen, in order to obtain a visa. So the basic premise of this is when a person comes into my office, the first thing I ask them if they're visiting the United States is, do they want to stay here temporarily in some form of status in order to, to plant their roots, if you will, and then in conjunction with that, work on getting their green card. And in most cases, the answer is yes. And that's how we start our conversation, where I start explaining to them the various non-immigrant visa options, which are required if they came in as a tourist, in terms of changing their status from the tourist category to something else. Tourist visa itself, which is the first visa type on a non-immigrant scale, the B visa, can be extended. The status itself can be extended for another 6 months. Usually, foreigners are stamped at the Board of Entry for a 6-month period, and then they have the ability to extend that period for another 6 months for up to a year. So that sometimes buys people a little bit of time. The F visa is a student visa. Foreigners can enroll into schools and put in a document called I-20 and apply for student visas. J visas are typically for cultural exchange purposes, and it does offer work and doing various things of that nature. There's different subcategories on the J visas, which we don't have time to go into today, but I just wanted to give you a quick overview. H visas, which is the most common work related visa, where there's a job offer and a person in professional capacity, like a computer engineer or or something like an accountant where a bachelor's degree is required for a position, is offered a job and then obtains a work visa. H-1B is often referral. That the visa referred to as H-1B. E classification is a common small business investor type of visa where people are either opening up a business or purchasing a business. And then the L visa is referred to as a intra-company transferee, where there is already a company in existence abroad, and that company is opening up a branch or subsidiary office in the U.S. and transferring a manager or executive or somebody with special skills to work in the U.S. O visa is for extraordinary ability personnel. Oftentimes, these are actors, directors, producers, entertainers, athletes. Sometimes fall into these categories as well. P visa is more common for athletes and musicians. So some of the stuff where a person can qualify for an O can sometimes also qualify for a P visa. So we look at it and see which one would be more appropriate for them, and so on. So there's a whole alphabet of visas. That's really not our topic for today, but I wanted to give you kind of a quick overview of them. A person, in order for them to stay and wait for the processing of their green card, needs to maintain some form of non-immigrant visa. These visas can be either work authorized or non-work authorized. The first two are generally not work authorized statuses, whereas the latter ones are. And most of them have an expiration period. They're limited in some duration of time. So let's turn to the immigrant cycle. The question often comes up, okay, well, I'm in the United States, that's all great. I have a non-immigrant status. I might have extended my status to another category, but ultimately, I don't want to be here without having a green card. I want to be a permanent resident and down the road, perhaps become a U.S. citizen. So they ask me, well, how do I do that? How do I become a permanent resident in the United States? And that's where that immigrant side comes in. So there's generally 5 different ways of becoming a permanent resident: through an employment offer, which is what we're going to be talking about today. It's the most common way of obtaining a green card in the U.S. Through an investment, which oftentimes requires an investment of $500,000 or more. That's that EB5 category that's written on there. Most people are familiar with that. Or marriage. So immediate family member, the most common is obviously through a marriage to a U.S. citizen. But oftentimes family members can sponsor, like a mom or a dad or an adult child, sponsor a foreign national to immigrate here as well. The waiting periods can be rather lengthy on the family immigration side, outside of marriage to a U.S. citizen. And asylum, somebody seeking asylum, refuge, they're afraid to go back to their home country. They're already in the United States and they have the basis of staying here. We can talk about how we can apply for asylum and keep them here. And then lottery, not all, but many of the countries are still eligible to apply for diversity lottery visas. Trump has put that into question, so that may not be around for much longer. Of course, Congress needs to rule on that, but there's a lot of push on eliminating the visa lottery program itself. There are 50,000 visas allocated for foreign nationals through this system. So I'm going to go back to this immigrant section. I wrote down this unemployment side. If you can see EB2, EB3, we're going to talk about that. EB2 is employment-based second preference. EB3 is employment-based third preference. That's what we're going to be touching on when we discuss this labor certification process when I start. The reason that I put on the investor side, investment immigration, EB5 and EB1, I added EB1 to it because sometimes companies, when they set up some type of an affiliate branch office in the United States, they can immigrate here as a result. The foreign nationals can immigrate here as a result of that process as well, in form of being an executive in that company or managerial staff. So let's go back so I can explain to you a little bit more in depth of why we're here and what we're doing. This is the heart of what we are going to discuss here. So what we're going to talk about is this whole premise of the labor certification. PERM, as it's often referred to, is a acronym for Program Electronic Review Management, which is really not, the acronym itself is not really important here, but what is important is the system has been in place for many years. PERM came into the PERM regulations came about in 2004, but prior to PERM, Department of Labor had other regulations allowed employers to obtain a permission, if you will, from the Department of Labor to hire or proceed to hiring foreign nationals that are necessary to perform various tasks. And the real basis of this is that a U.S. employer has tested the labor market and tried to hire somebody with certain set of skills. These skills can be either in form of education or prior employment history, or combination of both, or some type of a special skill that's necessary to perform the job. The employer tested the labor market. There are rules regarding how to test the labor market. Has not been able to hire or find an appropriate person to work for them, and they've proven that to the Department of Labor, and as a result of that, Department of Labor has issued a labor certification, which is a permission again to the U.S. employer to proceed in terms of hiring the foreign national. But in order for them to hire, we need to go through various steps. So the first and the most important step is the labor certification, that's followed by steps that are necessary through the Immigration Service and sometimes through the Department of State. So I don't want to overcomplicate this, but the Department of Labor, if you want to turn to this, let me flip to this page so you can see the employment-based immigration steps. I think it'll be easier for you to follow it this way. Yes, okay, so employment-based immigration, 3 different steps. The first step is, as I just explained, is with the Department of Labor. And the Department of Labor, the first thing that we do with the Department of Labor is that we submit something called a prevailing wage determination request. Department of Labor, once we have a job description in place and we have a job title, we submit that information to Department of Labor, and Department of Labor, within roughly about 2 to 3 months, will come back to us and provide us with the wage determination. In other words, they will give us the appropriate wage that the U.S. worker is an average wage, if you will, it should be paid for this particular job being described on the prevailing wage request, the job that we're going to be using for our labor certification. So they come back to us. Obviously, we put down the job requirements, what we're looking for in terms of education, employment history, and special skills, and that's where they come back with and give us that determination. The recruitment steps. Recruitment steps are the steps that are necessary and dictated by Department of Labor to adequately test the job market. So there are different steps in place that are followed, and we're going to go through them in a second. Depending on what type of job this is, a professional occupation or not professional occupation, like a laborer or unskilled worker, if you will. The professional occupations require more recruitment steps. Department of Labor also conducts periodic random audits. And in all honesty, these audits are approximately 20% of the time, so probably 1 out of 5 of our cases is audited. But these audits are fairly standard. They want to verify the fact that we followed the steps that are dictated by Department of Labor in terms of doing the recruitment, and we keep accurate records of these steps. And response to these audits are followed literally within a week or two of when after they make a request. So it doesn't really delay things in terms of approval by more than a month, maybe 2 months at the most. Processing times for labor certification. There are 2 bases for this, as you can probably already tell. The first base is that we have to conduct recruitment, and recruitment does take time. And we have to also set up the job, obtain the prevailing wage determination, and all of this takes approximately 6 months to get all of that done and to submit the labor certification for processing. Once the labor certification is submitted, the processing time is about 4 to 6 months. So generally speaking, within the year from the time that we start working on this type of case, we receive a determination from Department of Labor, generally certifying our request, giving the employer the labor certification. Advertising costs, these are the costs involved in actually placing the ads. The costs that are incurred are generally for print ads. There are 2 Sunday ads that are required for all advertisement. And sometimes we use a local newspaper in addition to that, or ethnic newspaper. And these are the costs that are involved for this. Everything else, we have agreements with various agencies or online postings that we do at no cost. The typical advertising cost for this process ranges anywhere from $300 to $500, depending on the size of the ad itself. So that's the step number 1 with the labor certifications. Step 2, once the labor certification is obtained, we go to Immigration Service, now referred to as Citizenship Immigration Service, to apply for something called Immigrant Worker Application. And during this step, this is the first time we're actually facing Immigration Service. We've worked on the case for approximately a year and have not done anything with immigration. So now immigration wants to know, is the job offer still open? In other words, does the employer still want this applicant to work for them? So we have to verify that fact. And 2, the more important factor, does this employer have financial ability to pay the prevailing wages? Remember that the wages that were obtained from Department of Labor in terms of salary to this foreign national. So the financial ability can be shown in 3 different ways. The most common way the employer shows financial ability is through their corporate income tax returns. The adjusted gross income is income after expenses, sometimes referred to as net income. Shows the amount of revenue the company generated, and if that amount is over and above the offered wage, that is sufficient for us to proceed. Net current assets is another way for an employer to show that their financial ability is there. And that is liquid assets generally, like cash in the bank, corporate bank account, accounts receivables, so income earned by the company but has not been received yet, minus any current liabilities. So if the company owes for rent, immediate or past due on certain rental payments, we have to subtract that. That net amount, the net current asset amount, can be utilized also for the purposes of this labor certification process. Again, the amount has to be over and above that or above the prevailing wage for the offered salary. In some instances, the third way of proving financial ability is through payroll. So if the employer is working for a company, oftentimes on the H-1B visa, and the big thing is they're paid the prevailing wage, the wage that's determined on the labor certification, and oftentimes that's not the case. The H-1B salary doesn't have to correlate with the labor certification prevailing wage salary. So we need to be really careful with this. But if it does, then that's another way to meet the criteria for financial ability that the employer must have. I check this before we start working on the case. So I don't wait a year and then start reviewing this information. I check it up front, and that's done to prevent problems that the employees face when they're not familiar with what their employer's financial abilities are. And I don't want this to be a surprise, so I prefer to review this and verify this and then have a calculated decision made by the employee and the employer to proceed with this application. Processing times for the immigrant worker application, I just checked. The current processing time is about 5 to 7 months. That's the regular processing time. The premium process, where a person pays an extra $1,225, that's an optional government fee. That can speed up the time of adjudication to down to approximately a month and a half of time. They promise to review a case within 15 working days, which is 3 weeks. If there's requests for documents, it might end up in another 3 weeks before the decision is made. So difference is $700 standard fee, regular processing fee, and then the $1,225 additional if you want the premium processing. And then finally, the last step, and the last step is broken into two different criteria, step 3A and step 3B. It's not that you have to do both, you have to pick one of them. If you are processing your green card within the United States, in other words, you maintained your legal status, the big picture that we talked about when we started this webinar, you maintained your non-immigrant status or somehow protected under the old law, and I'll touch upon that later as well. You can apply for the green card within the confines of the U.S. The processing time for these green card applications have increased significantly since Trump took office, and are currently 15 months or higher. So the average time is about 1.5 years, and the reason that it's longer now, it used to be under a year, is because these cases are now moved from the service centers, which is the large facilities where immigration cases are being reviewed, to local offices for interviews. So their preliminary review and adjudication, collection of documents is done at the service centers, and then the questioning interviews are done at the local immigration offices. So that increased the processing times. Government fee for the green card applications in these type of cases is $1,225 currently. All of these fees obviously can change. sometimes a person does not want to wait this long, or for various other reasons, because of travel or other commitments outside of the U.S., or perhaps other family members that have remained abroad while the foreign national is applying for the process, working in the U.S. There may be many different reasons why a person might want to do this abroad. And that's step 3B, where we are processing that individual's immigrant visa instead of a green card outside of the U.S. at the U.S. consulate. There are two sections of the U.S. consulate: the non-immigrant and the immigrant section. The immigrant section deals with these type of visas, where a person has to undergo medical exams and biometrics, where they review obviously their criminal records, and then they come in for these interviews at the Department of State, the consular offices, for their immigrant visas. Government fee there is $425. Processing time is shorter. That's another reason why some people choose this route rather than the 3A route, because literally the processing time is about 4 to 5 months. That's significantly shorter than the current time for the green cards of about 1.5 years, the 3A. So
Chal.
These are the steps of going through the employment-based immigration process. All right, so let's see where we're at now.
Yes.
Okay, so we've covered the big picture. We've talked about various non-immigrant visa types to maintain status in the U.S. We talked about various immigrant types of visas and abilities to obtain their green cards. We then put our focus on the
We will go on there and ask me the information. You're going to pay the things today.
And now
only primary
point your attention to the actual recruitment steps. And these recruitment steps, I also have a diagram for it. Is something that we do in our office, but I want to run through them quickly so you have some idea in terms of what's required for the labor certification recruitment process. There are certain types of required recruitment to the Department of Labor regulation mandate. SWA is the local office in Los Angeles. It's Employment Development Department. It's a worksite enforcement office is what that stands for. And every jurisdiction, every county is a different locale. The Department of Labor requires that there be a posting with that office for 30 to 45 days, so that the unemployed, generally speaking, can look through it and see if a job opportunity fits their needs. That's one of the required steps on all labor certifications. Internal postings is another one. So somewhere an employer's job site, lunchroom, or otherwise.
Hey, turn your mic off.
Be around in the internal posting is placed, showing that there's a job vacancy. And then newspaper. The newspaper requirements are fairly strict. It has to be one of the main papers, or in terms of circulation, use Los Angeles area. It would likely be Los Angeles Times or Daily News. These are the two common newspapers that are used. There's a requirement for 2 consecutive Sunday ads, and that's the costly. That's where the costs primarily are from. When we talked about costs for advertisement, that's where the costs are coming from for these Sunday ads. The additional recruitment requirements for people with bachelor's and master's degrees. They're usually employee referral program that generally runs 10 to 15 days. Job search engine of some sort, like monsters.com, 10 to 15 days. local or ethnic newspaper, generally for about a week or more. And then there are optional recruitment steps where we can conduct also on-campus recruitment, job fairs, radio ads, TV ads, and use the company website as well. There are the first three required recruitment classification for ads are mandatory for all job types, whether a person is applying for professional work like a computer engineer or something that they consider to be skilled work like a plumber or somebody who's not required to have a particular degree, bachelor's or higher. So everybody goes through the required steps, and the additional steps are utilized for more professional occupations. So that's where we have the approximately 3 months of recruitment that I just covered. Employment categories, there are different employment categories that we utilize. Oftentimes referred to as EB1, EB2, EB3, other workers, and it lists here on this chart what we're talking about. EB1s are generally people with extraordinary abilities or executives and managers, and they tend to skip the labor certification process altogether. They go to the second step of the 3-step process for employment-based immigration and bypass the Department of Labor. So we're generally focusing in our discussion on people that are in the blue on the chart that you see, EB2, EB3, and other workers. EB2, in order for a person to be classified in the EB2 category, they need to have either a master's degree or a bachelor's degree with 5 or more years of related work experience. The EB3 is a very broad category. Majority of the clients that we represent fall into the EB3 category because it covers anyone from any job opening from 2 years of experience required for that job to bachelor's degree and up to 5 years of experience in terms of qualification for the job vacancy. And then there are other workers, that's those that are unskilled work, for example, domestic service worker, housekeeper and whatnot, that do not require, they require only maybe minimal experience, 3 months or more, sometimes none at all. These are other workers, up to 2 years of work experience. Why is this important? Why are we talking about these categories? The reason we're talking about these categories is because of the processing time that it takes for immigration to review these cases. Oftentimes depends on the category that the person is in. Generally speaking, those applicants that are in the upper categories, upper meaning EB1, and then going down to EB2, EB3, and so on, are processed quicker. There are more visas available. There's a limited number of visas. These are immigrant visas I'm talking about, the green cards. Immigrant visas turn into green cards. There's 144,000 total immigrant visas, employment-based immigrant visas allocated every year, and they tend to utilize them from the top down. So whatever is not used in the top kind of simmers down to the bottom of the stack. And because of that, the people that are in the upper categories tend to wait less in terms of adjudication time for their cases. Having said that, there are many exceptions to this rule, and the best way to know exactly how quickly the particular categories are advancing is to look at the Department of State visa bulletin that comes out monthly. I just reviewed the bulletin that's already posted for August 2018. And the EB2 and EB3, as well as other worker categories for most countries, are open, meaning that at this point in time, it isn't important. It's not really time-wise, it's not really relevant in terms of what category, what job description is indicated on this labor certification in terms of the speed of adjudication, how quickly the case will be adjudicated, because visas are available in all of these categories that we're discussing here today, EB2, EB3, other workers. There are backlogs for countries like China, India, Philippines, and sometimes even Vietnam, Mexico, El Salvador, Guatemala, and Honduras. But for most cases that we're discussing, all the other countries that I did not mention, the visas are open. For more detailed information on the foreign country that you're from, it's best to speak to me directly so I can guide you properly. This webinar is for general discussion, not for case-specific discussions. I hope everybody understands that. But just so you know, currently the dates are open in these categories for most countries except for China, India, and Philippines that has some backlogs in these visas. So I'm going to also point to one last chart. I know you've been looking at charts for most of this webinar, but it's important for you to get the understanding, and I think charts are helpful to dissect some of the information that I'm referring to. So eligible applicants, people often, going back to my original discussion, I'm sitting in front of a client, and the office client says, well, I have an employer wants to help me get a green card, I'm working for them, or I plan to work for them, and what do I need to qualify? So we already talked about what the employer needs to qualify to do this. Employer obviously needs to have the desire to sponsor the applicant and the financial ability to do so. We discussed the different financial ability requirements. So now we're focusing on the applicant, him or herself. What is required of the applicant to be able to obtain a green card? So the most obvious one is the person is in status and working for the sponsor. So if the person has an H-1B visa or TN visa or some other type of work visa, it could be an L visa or something else, it could be an E visa, any work-related status, allows that applicant to then change that status, because they are here legally and they are working for the employer, to what's called an adjustment of status, which is a green card application. And that was in that one of the charts that I showed you, the step 3A of application for the green card. So that's the most common scenario that I see. They're already working, the employer likes them, they're legal in the country, and it's a conversion from their non-immigrant status to their green card. The other category is the person is in status and not working for the sponsor. So they might be either working for a third party or not working due to their status restrictions. So what am I talking about, status restrictions? Somebody might be going to school, for example. They're legal here, but they don't have a work authorization. So they're going to school, and yes, an employer can sponsor them for labor certification while they're attending school. That's a very common question that I get asked. In fact, employer can sponsor them in any status, so long as they're legal. So these are the scenarios, and in most cases, when we're talking about this, a person in status and not working for the sponsor, a sponsor wants them. They want them to start working for them in the future. They may not have an immediate need for them, but they do want to hire them in the future for various reasons. And they hired our office to help conduct this recruitment and labor certification process. The third category are people out of status. They're not legal here. They either entered illegally in United States, or they entered legally, perhaps as a tourist, and they didn't do anything to extend their status, so they lost their status. They're here and they're out of status. However, this category, the third category, these are folks that are protected under the old law. The old law that I'm referring to is Immigration and Nationality Act, Section 245I. And there were two different periods where people, by virtue of having an application filed on their behalf, either through a family member, so let's say a mom or dad or an adult child or a spouse filed something for them, or an employer filed a labor certification for them, or another type of immigrant petition. And that filing was done on or before end of April of 2001. If we have proof of that filing, even though these folks are out of status, they're still protected under the old law, this section that I'm referring to of the law, and it gives them the right to convert to a green card, even though they're out of status. They pay a penalty of $1,000 for being out of status and proceed to filing their green card, much like anybody else who is in status. And then that's a great thing for people to use if they have that ability to use it. And finally, the last category of people, people that are out of the country. Remember I said the labor certification process can be done for somebody who's not even inside of the U.S. So a person can, an employer can start the process while a person is residing abroad, and we can do that for them. There's no requirement for maintenance of status. There's no violation of status. The person has been here, but they've never violated the status or never been here. And that allows them to proceed and obtain their green cards. They usually do this from abroad through the Department of State, through the route that I explained on the previous outline, 3B, last step for the immigrant visa processing. Okay, so that summarizes most of the process that is required. That is an employer-driven process, so we do need to have an employer in place, and oftentimes I need to speak to that employer at least over the phone to get a concurrence. The labor certification portion of the case must also be engaged. My office needs to be engaged by the employer to assist them on, so it cannot be an entirely employee or applicant-driven process. But we were able to handle these minute issues by having two separate agreements, one with the employer for the initial stage with the Department of Labor and the balance with the employee. These are things that we can easily work around so long as we have the consensus from the employer that they want to do it, check their financial ability, they're capable of doing it. We check the applicant's eligibility. The applicant is eligible to go through this process. So I have all of these vehicles in place before we even begin. And because of what we do in terms of screening before we start these processes, our success rate is well over 95%, going through each step of the way through obtaining person's green card. I'm happy to answer questions. If there are questions, it might be best if you have more specific and detailed discussion that you want to engage me on, to come in for a face-to-face consultation. Like I said, these consultations are free of charge. The initial consultation I offer for free. And I can steer you in the right direction in terms of when and how to proceed, whether it's for you or for a relative of yours or a friend to do this for. So I don't have much more to say on this subject. If there are questions, I don't know if we're able to hear some of the questions. You're welcome to, if you want to put on your turn on your microphones. If you have questions for me, I'm happy to answer those questions. No questions? Okay.
Hey, James.
Yes.
Hey, this is Hedy. How are you?
Good, good. How you doing, Hedy?
Good, good. So I missed, unfortunately, the first half of the webinar. Just wanted to ask if I could request any of the documents that you shared during the webinar. I don't know if I can just do that separately. Are they available for us to review?
Yes, absolutely. I'll have my assistant forward you these documents. I'll give her your email address, so she'll do it right after our webinar.
Awesome. Thank you very, very much.
Yeah, and then there's more information available, by the way. We have an ebook that's dedicated to the subject.
Okay.
It can be downloaded from the website rootlaw.com, or I can ask Elena. Elena is my assistant. She can email it to you as well. It has
yeah,
more.
If she can, that'd be great.
Mm-hmm. No problem.
James, one more question.
Sure.
I'm going under PERM process right now, and I just received an employee work authorization card and still waiting for interview for the green card. What do you think was the average time for waiting interview after employee authorization card?
So how long did you wait to receive your employer work authorization card? How long did it take you to receive it after the case was filed?
Just a couple of weeks.
Couple of weeks. Okay.
Yeah.
So the current processing time is 15 months and can be up to 22 months for
after receiving employment authorization card to interview.
From the time of filing, not they don't count from the time that you received your employment authorization card. Generally, the employment authorization card is processed independently of your green card application. They look at your background information. So if they are able to check your background and approve it, then they issue you a work authorization card. It's just a benefit that you have while you're waiting for your green card approval. But it doesn't have anything else in terms of how fast the green card application is processed. Your I45 application, the green card itself, was submitted to a service center like Nebraska Service Center or Texas Service Center, and they review the case, and then once they're done with their review, oftentimes ask for additional documents or information, and then they're not done because of the new mandate from Trump administration. These cases are now being called for interviews. So then they transfer the case over to the local office for interviews, and that's where that whole period, about 15 months, sometimes longer. I'm counting from filing your green card application to the time of you actually receiving it.
Gotcha. Thank you. I see.
No problem. Anybody else?
Yes, James, I have a question. So once you receive the I-140, can you start working for the employer?
You can't work for the employer with just an I-140 approval. You need to have work authorization, just like the last person who was asking you questions. He already has an EAG card, work authorized card, that allows him to start working for that employer. But the I-140 approval itself is not enough.
Okay, so you literally have to wait.
Yeah, the work authorization card is part of the packet. Submission for that request is part of the packet that's sent with your green card application. The referred to as I45 form. So that packet includes your request to work. And when that work authorization is approved is the period that you can begin working for the employer that's sponsoring.
Perfect. Thank you very much.
No problem. Anyone else? Okay. So I'm happy to do this for you guys. I will do more of these webinars in the future on different topics. I look forward to you joining us for future discussions. And if you have any questions, I'm always here and happy to help. All you got to do is just reach out by phone, or you can go on the website. The phone number is 323-456-7600, and the website is rootlaw.com. Thank you.